ABC's Ken Delanian spoke with various legal experts who predict the Supreme Court's decision on abortion is likely to set off a wave of legal and political disputes among the states and federal government, unlike anything we've seen, perhaps since the days of the Civil War. Those legal experts point out that with some states allowing private lawsuits against out-of-state abortion providers and other states prohibiting cooperation with abortion investigations, the issue is likely to pit state law enforcement agencies and court systems against one another in dramatic fashion. In this scenario, it is conceivable that a person could be wanted for a felony in an anti-abortion rights state, but protected from extradition in a pro-abortion rights state. The governor of Massachusetts has already imposed rules forbidding state officers from cooperating in abortion investigations. California's governor signed a bill seeking to protect from civil liability anyone providing, aiding, or receiving abortion care in the state. Texas law, however, lets private citizens sue out-of-state abortion providers, and Missouri is considering a similar
it is certainly going to be rather complex. We're going to be getting into areas that we haven't been into much lately. I think we have James back. So James, you wrote an article some time back that talked about a good way to reform the court in a way where it's not luck of the draw. It takes away a lot of the heated rhetoric, this sort of zero-sum game. And if I remember it correctly, it said each presidential term, gets 2 appointments. There are term limits, and that's the way you ensure again that people don't look at every nomination as a fight to the political death.
Yes, and sorry for my disappearance. Glad to rejoin you. This is a proposal laid out in most august detail by a group called the American Academy of Arts and Sciences, based in Cambridge, and it really is, as sort of respectable as an organization as you can find. And they said that the answer would be to switch to a scheme of 18-year fixed terms for the 9 justices that would come up every 2 years. And the huge advantage, one advantage would be just avoiding all the vagaries of somebody deciding that he or she will just stay there forever. The more important advantage, I think, is, as you said, Joe, it avoids every single fight being to the death, because every president would know that he or she would have 2 shots at appointments during his or her term. And the next, each election would be about the next 2 appointments, not what the next 40 years in the court would be. There are ways this could be done with purely constitutional consistency, as long as the judges, after their 18 years, had jobs in other courts, other parts of the court system, et cetera. But it's worth reading this report in detail as a way to drain some of the poison out of what has become a really distorting part of our legislative and judicial process.
Well, you also have written about just the fact that we have people well into their 80s that stay under the courts when it's probably in everyone's best interest. That again, they get cycled out. They're 18-year term limits. There's not this gruesome death watch on aging members of as there was with RBG, to figure out if she can stay alive until a Democrat's in. Or I remember Sandra Day O'Connor being overheard when it looked like Al Gore was going to win, saying to her husband, "Oh God, it looks like we're going to have to stay in Washington another 4 years."
Yes, and if you consider how important the Supreme Court has become in the clock-wheel geometry or machinery of democracy, it depends so much. We all have to place so much trust in it. To have its workings be dependent on these accidents of healthcare and of people's guessing about their mortality, it would be much more normal and stable to have a way to have each administration have 2 appointments, and then it would be another part of a regular turnover. I should say also that I'm aware of no other supreme judicial organization around the world that has life tenure in democracies. They all recognize the need for some kind of refreshing in that role. So I think this would be a good step for us.
James, good morning. You also write in the piece about expanding the court, which is an idea we've heard in recent years from many progressives. Others say, well, progressives aren't getting their way on the court right now, so they want to change it fundamentally. What's the argument for expanding it, and how do you think you'd begin to go about that?
I think the argument for expanding it would have constitutional legitimacy in these two ways. As you all know, the House of Representatives itself used to expand its size after each census to keep the number of representatives to population more or less constant. It only stopped expanding about 100 years ago. And so you could have the argument first that a modern House should be bigger than it is. It should have 100 more members or so, which would make, I think, fewer really polarized districts. The Supreme Court has expanded over the years, and originally the idea through the 1800s was that as the number of circuit courts expanded, so too with the number of Supreme Court seats, and that reached a equilibrium with 9 circuits and 9 seats. There now are 13 circuits. It would be perfectly logical and historical to say, for a whole variety of reasons, the court should expand to its natural 13-member role, consistent with the number of judicial circuits.
All right, James Fallows, thank you very much for coming on this morning.